Good afternoon, everyone. We're going to give Zoom a minute or so to add everybody into the room, and then we'll get started. So just sit tight. We'll get started in just a moment. Thank you. Good afternoon, everyone. Just going to give Zoom another 30 seconds or so to add people into the room, and then we'll get started. Thanks so much. Okay, I think we will go ahead and get started, and people can join as they come along. Thank you, everyone, for joining us. I'm Greg Phillips with Duke Communications. Welcome to this Duke media briefing on police reform. The death of Tyre Nichols at the hands of 5 Memphis police officers last month has strengthened calls for policing reform, given the disproportionate killing of unarmed black citizens by law enforcement. We have 3 Duke experts with us today from the School of Law to discuss how federal, state, and local authorities can reduce violent interactions between police and citizens. With us today is Brandon Garrett. He is a professor of criminal and constitutional law and directs the Wilson Center for Science and Justice. He's co-author of Changing the Law to Change Policing, First Steps, and a member of the American Law Institute's Project on Policing. Also joining us is Angie Weiss-Gamel. She is policy director of the Wilson Center and a public policy scholar focused on criminal and legal reform. Gamel previously served as a senior advisor for public safety policy and operations in the Chicago Mayor's office. And we have Ilana Fogel. She is a clinical professor and director of the Criminal Defense Clinic at Duke Law. Prior to joining Duke, Fogel was a federal public defender and has been an advocate for oversight and transparency in the use of new technologies in policing. Good afternoon to you all. Brandon Garrett, we'll start with you. In his State of the Union address this week, President Biden called for more training and accountability for police officers and community investments to help prevent crime. Do you think this is the right approach, and at what level can those investments be made?
Investments are certainly needed in all 3 of those different directions, but in terms of lessons from what happened in Memphis and what's been happening, really weekly across the country in terms of excessive force by police and breakdowns, ranging from things that require discipline or even civil rights actions or prosecution of police officers, or misconduct that contaminates criminal investigations, lying, perjury, harm to evidence, wrongful convictions. These are all issues that we care about at Duke. I founded the Wilson Center here. We have a criminal defense clinic, a wrongful convictions clinic. At Duke Law, we're deeply concerned with all of the ways that policing can both create justice and deep injustice. A lot of that accountability, though, and support that needs to happen at the local level needs to be addressed through serious legal change. We've learned, for example, that 4 of the 5 officers involved in this killing had prior discipline. Tennessee is not one of the states that creates enormous obstacles to ever accessing prior discipline, prior problems with police officers, but it certainly doesn't require that information be collected, studied, aggregated. Here at Duke Law, our colleague Ben Grunwald, who had a conflict and couldn't attend, has done really important work looking at the problem of wandering officers, police hiring, and there's a deep need to collect data on police misconduct, whether it's police perjury, discipline, use of force. We can't have problem officers. It's sort of not just about these 5 officers. If we have an entire system which can hire officers that are poorly qualified, and then when they predictably violate training, violate policy, nothing happens. There's also a need, like training doesn't help and accountability doesn't help if there aren't serious rules and policies in place. Some states have really rethought when is force allowed. And so many agencies have grayer rules where there is more discretion about when to escalate. We saw here in this video that, these officers were escalating right away in all sorts of ways and killed someone. To the extent that those officers didn't realize that was clearly illegal, it's also a problem for state law and not something that you can just solve by after the fact disciplining these 5 officers or 6 officers or however many are ultimately held accountable for what happened in Memphis. We've seen this happen all around the country, and only a very small number of states have rethought the ground rules for when police can use force on people.
Absolutely. Thank you. Certainly, it's a massive problem and an ongoing problem. We're going to come back to some of those issues that you mentioned. Ilana Fogel, I'd like to move on to you and zero in a little bit. I mean, from your experience as a public defender, how is it that so many routine civilian interactions, such as traffic stops, escalate into charges and violence, as we've seen with George Floyd, Tyre Nichols, and countless others? And what, if anything, can change in the culture of policing to prevent that?
Yeah, I think, much of the answer to your first question comes about in the second one, right? A lot of it comes down to the culture of policing and the attitudes or beliefs that officers approach those initial encounters with. So, just generally speaking, what we tend to see from my perspective in the courtroom is we'll receive a police report that describes some sort of low level or routine, as you described, an interaction of a traffic stop or even a allegedly consensual encounter that in many cases escalates to just general criminal charges. Either the officers say that they then observed something that was apparently illegal, or subsequent investigation, they had reasons to order people out of the car and then pat down their body and found drugs or weapons. So that's how things tend to escalate to criminal charges in your average case that we see thousands of times a day throughout the country. Of course, these examples are the extremes where those escalate not just to a charge or the intention to charge, but unfortunately violence and in these circumstances, death. But that sort of graduated response, right? First, there's an interaction, and then it gets more contentious or more probative into what officers claim are observations, is sort of the general run-of-the-mill of cases. Much of the litigation that then occurs in the courtroom is what actually occurred, how reasonable those inferences are, and the further steps taken or the further interactions had from the initial reason that the police approached somebody in the first place. To your second question, absolutely, I think, a change in culture is what many reform activists and advocates call for in response to these things, in addition to the legislative and legal changes that Brandon mentioned. It's a sort of questions of what sort of policies are not only enacted, but whether they're enforced, what leadership in the departments emphasizes, what's celebrated versus, it's not just what's punished, it's what's celebrated. And if anything is punished, even if the correct or better policies are in place, how there's communication about misconduct, right? So much of what we do in the courtroom is to bring about those inconsistencies and bring to light problems with the officer's reports compared to other evidence that comes about, but there's often a disconnect there. So is there any communication when an officer is found to have been untruthful on the witness stand? Does that get back to their superiors? Is there any action taken? Or are we just glad that got intercepted in an individual case, not considering the hundreds of other arrests that officer may have made and not been challenged on? So it's certainly a multifactored problem with multifactored solutions, but you're absolutely right to point to culture as being an important one.
Absolutely, thank you. And as we kind of move on and in identifying the problem, Angie Weiss-Gamel, you worked on public safety policy for the city of Chicago. Can you give a sense of how much control municipalities have, over the oversight of their own law enforcement agencies, and whether we've seen cities actually change the way they do this oversight since George Floyd's death almost 3 years ago?
Yeah, so the police chief, as you probably know, is typically appointed by the mayor or city manager of a city and confirmed by city council. And the chief does then report to the mayor or city manager. So that enables the mayor to have a certain amount of oversight and direct control of the department. But it also takes a lot of resources to do that. So in my time in Chicago, I managed a full staff who was dedicated day in, day out to working on police department issues. But most cities don't have those sort of resources. And so it does end up being more of a high level sort of management. Some of the things that mayors or city managers can do, they can ask their police departments to review and revise policies. That has certainly happened quite a bit in the wake of George Floyd's murder. They can also issue executive orders. So executive orders can be really useful in forcing departments to to make public certain types of records and release video footage and things like that. So that's certainly a tool in the tool belt. And then cities have budget control over their departments. And that's, of course, something that has been a hot topic over the past few years. Some cities have cut police department budgets. Others have just made line item adjustments, but even those line item adjustments can be effective if you're moving funding away from certain tactics and instead emphasizing the need for community policing or for training, and making shifts in the number of police officers who are dedicated to certain types of activities. And then I'll also note that the city tends to be a party if the police department is under a consent decree. It's the city that is a party to the consent decree. And that was the case in Chicago when I was there, which gives the city a particular stake in the, actual reforms that are taking place under that consent decree. And that can be really important as well. Some cities since George Floyd have also established civilian advisory and review boards to strengthen community oversight of police. Those boards can investigate allegations of police misconduct and make recommendations to the chief or sheriff, which can be really powerful. But transformative change is yet to occur. It's really hard to do that. So all of these things sort of help move in the right direction. But I don't think that there's been a transformative change in terms of how cities manage and oversee their police departments, unfortunately.
Absolutely. Thank you very much. And thanks to all three of our panelists for those opening comments. We will open it up to questions now. Thanks to everyone who submitted questions in advance. You can also pose question in the Q&A window at any time. If you'd like to ask a question out loud, raise your hand in Zoom and we will unmute you when your turn comes around. If you're calling in by phone, you can raise your hand by pressing *9. Brandon Garrett, I'd like to come back to you first. You co-authored a set of recommendations for policing reforms at the state, federal and local government level. Everybody wants to know what can be done. What are some of the suggestions you have that you think could be most effective?
See, I was part of a group, it's called the American Law Institute. They produce authoritative restatements of the law, like on contracts and topics like that. But these principles of policing were the flagship effort by this group of lawyers, judges, and we had an enormous number of police chiefs and leaders from civil rights groups, professional policing organizations, all as part of these committees vetting the set of principles. The idea was that we wanted to set out much more detailed recommendations than things like the 21st Century Policing Report that the Obama administration put out. Detailed sets of guidelines for law enforcement and to some extent addressed to courts. But that said, much of this needs to be turned into legislation and police policies. Here at the Wilson Center, we've been drafting some of these. We have seen a flood of legislative activity, especially since the killing of George Floyd. Since his murder, we saw a surge in states passing new laws to regulate police, but not very many of these laws were passed. Like less than 10%. We're about to do a report on just how many laws about police actually get passed. Not very many, and many of the laws, addressed to sort of useful but not particularly hard-hitting subjects, like more resources for training, which is good, but not actually changing the rules for when police are allowed to use force. Very few states have done that, and so we've seen a lot of activity gesturing towards the need to improve policing, but not particularly hard-hitting requirements, including coming out of this notion that, well, policing involves kind of hands-on tough guy stuff. We need to just, you need to just use your judgment on the street and officers know what's best. I do think that model of policing, you just got to do what you need to do in the moment, has started to fall apart. We've realized that no, it actually takes sophisticated training and real guidance and real discipline, that you don't want officers to act like criminals themselves and just act impulsively and act violently. That's exactly the kind of behavior that we do not want to be modeling. One of the core principles of this entire effort has been that, we need to be actually setting rules for police. There actually need to be laws. Police are law enforcement. They actually need to be regulated by laws. And that's the overall message of this entire project, that there are very few laws that give police the kind of guidance and support or requirements that they need. Police have been exempt from all of the rules that most government agencies have to follow, where if they're going to set priorities, they actually have to announce them to the public and say, this is how we're going to do it. And so whether it's police, using without any authorization some piece of technology which people later decide is creepy and we don't want police to use it, like a Stingray or a drone surveilling all of the city of Baltimore, or whether it's using weapons in ways that we never would have agreed to, or buying tanks. Why does our agency have a tank? We never voted for that. There needs to be more democratic accountability, but that starts with people being willing to say, we will set this out in our laws and in our local regulations. And that has started to happen. But even in sort of the third year since Floyd's murder, we've seen a real decline in willingness to actually do lawmaking around policing, and sort of a false narrative that this is sort of abolitionist, or you're just against police if you're trying to regulate police. And that's not right. This is about supporting police and making sure that policing is professional. But without getting into particular proposals, of which there are many, the overall goal is to have law surrounding policing.
Absolutely. Thank you very much. Ilana Fogel, I'd like to come back to you on this issue of accountability that Brandon Garrett was just talking about. George Floyd's killing happened in 2020 and things don't seem to have changed. And last year alone, almost 1,200 people were killed by police officers, but only in 9 of those cases were any officers charged with crimes. Why is that so low? And does that kind of speak to the lack of accountability that Brandon Garrett was talking about?
Right. This, in some ways, is sort of the other side of the coin of what Brandon Garrett was talking about. There's the policies and a dearth of them, and the law that law enforcement officers are subjected to. But then the other side of that is enforcement or putting, law is not self-effectuating. There have to be decisions and actions in order to give them meaning. So there are many reasons, I think, why there's such a disparity between the number of killings and the number of charges. Some of them, they relate back to what I was mentioning about what happens in court, right? In cases where there isn't independent footage or other surveillance or witnesses that can contextualize the officer's accounts or point out inconsistencies, in a situation where an unfortunately tragic occurrence occurs, but the only report is what the officers themselves say happened, prosecutors can often make a decision based on what evidence they believe they have to not pursue that charge. The other depth to that in those prosecutorial decision-making contexts are the actual legal standards, which can be quite forgiving in these circumstances. The question about whether an officer's use of force was appropriate, even when lethal, in use standards like whether that was a reasonable decision based on the factors. Some of Professor Garrett's work calls for those standards to be more stringent, right? Can that instead be a question about whether the officer's use of force was necessary rather than just reasonable under the circumstances, to put more requirement, particularly in these instances when we're having death as a result of these actions, for them to have been truly justified and necessary rather than just perhaps explainable on one version of the facts that occurred there. And then, it's not just the prosecutorial decision-making that comes into play. In the Breonna Taylor case, the grand jury was involved. And certainly the prosecutor presents the facts and decides which facts to include and not to include in that presentment to a grand jury. But there's a public role for accountability here as well, right? When defense attorneys present arguments to juries or suggest that there might be an inconsistency in what actually happened in the officer's report, that's a public function of accountability. That occurs too in the grand jury, where members of the public are the ones who decide whether there's evidence to move forward and pursue charges. So those are other places for gaps and greater accountability and acknowledgement of some of these deficits between what can be contained in a report and what other evidence or facts may be. So for a myriad reasons, I think there's a disconnect between the tragedy, the scale of the tragedy, and the type of accountability that comes through the criminal system.
Absolutely, thank you. And on the subject of accountability, Angie Weiss-Gamble, I'd like to come back to you. Brandon Garrett touched on this idea of traveling officers and their past records not being kept up with. Several of the Memphis officers involved in the recent killing had prior reprimands or allegations of misconduct. What kind of rules can cities and states set regarding discipline and decertification of officers with complaints against them, and how do police unions play into that?
Yeah, so I'll start with the second part of that question first, right? Because in the 41 states that have police unions, they play an enormous role in officer discipline. So not so much an issue in North Carolina, but in most states it really is. And typical union contracts will set rules and procedures for investigating allegations of misconduct. This includes when, where, and by whom an officer can be interviewed, often including some form of delay, saying that the officer can't be interviewed until the following day after the alleged incident takes place, which of course creates an opportunity for the officer to confer with others and make sure that they get their story straight about what happened. And also means that even if there is no ill will, just memory is not as fresh when they're interviewed. The union contract also usually calls for expungement of records of past disciplinary actions or accusations of misconduct, which makes it really hard to take progressive action or to track potential issues with specific officers. And then union contracts will spell out grievance and arbitration rules that allow for robust challenge of adverse personnel action, usually offering up to 7 or 8 opportunities to appeal. And in each of those opportunities, it's more, it's another opportunity for the charges to be dropped or the allegations to be found unfounded or not sustained. And arbitrators can reinstate with back pay, and they have an incentive often to be somewhat friendly to the police because their future employment is at stake. If they if they rule too harshly against the police, then that police union isn't going to allow that arbitrator to be used in the future. So it's sort of a web of issues that unions can create in discipline. In terms of what can be done, the city can establish an independent body to investigate allegations of officer misconduct to make sure that it's not the police department themselves that are conducting the investigation. That can be really helpful. States can legislate the subjects of police bargaining to eliminate disciplinary procedures from being subject to negotiation with unions. That can potentially be really powerful. States can create certification standards and then create a database to track officers who have been disciplined, to track officers who have been fired, and if they've been fired for reasons related to misconduct, to decertify those officers so that they're not hired by other departments. So those are some ideas of proactive things that cities and states can do.
Absolutely. Thank you very much. I'd like to talk a little bit about some issues that came to light in the death of Darrell Williams in Raleigh's police custody last month. And Brandon Garrett, Darrell Williams had been tased 3 times. And we've seen that since 2010, more than 500 people have died soon after police used tasers on them. What are some of the policy challenges around taser use? Because it's often seen as a non-lethal alternative to a police officer pulling a gun, but clearly they often do result in death. And I'm sure that's a particular policy challenge. So do you have recommendations around that? What is the current thinking on how to reduce the number of taser-related deaths of people in police custody?
I think the most important principle, and it's a hallmark of the American Law Institute principles of policing and the different recommendations from professional groups I've been involved in, is that you have to have proportionate use of force, and that officers are sometimes given highly misleading training that here's a non-deadly tool, and so you don't have to be as careful with it. Well, number one, we know that some non-deadly tools can be deadly depending on how they're used, like if someone is tased excessively or if they have underlying health conditions that an officer might or might not have any reason to know about. But the more fundamental question is, why are you tasing this person? Why is it justified? What does the public safety need to incapacitate this person? Since it could be deadly or it could cause grave injury to someone, is it that important to stop this person, to incapacitate them? If the person doesn't identify themselves, you don't jump to tase them. Like, if you're investigating something very, very serious and you have good grounds to think that this person is an immediate threat to public safety, then there may be more justifications to try to use more tools to stop the person. But if it's just that you feel disrespected because the person didn't identify themselves, if it's a misdemeanor, if it's a property offense, then you are actually not doing your job as a protector of public safety. If you're doing things that endanger people's health, if you're endangering safety yourself as an officer in a way that's disproportionate. And that kind of weighing, like, what is the public safety benefit? Why are we arresting this person? Who is actually harmed in this community? That kind of balancing is not commonly taught. And so you have people stopped, you have people searched, you have people outright arrested, and you have force used, even if it's not deadly force, in situations where it's not clear that there's any meaningful public benefit. And that basic balancing, like, how are we actually protecting public safety here? And is what we're doing proportionate is often not taught. And even when policymakers have preferences, they don't make their way down to the actual rules that officers have to follow and the guidance they're given on the street.
Absolutely, thank you. Ilana Fogel, one of the things that was an element in the Raleigh case and in Memphis was this notion of proactive policing programs. Could you talk just briefly about what that is and some of the issues that are involved in it?
Sure. So generally speaking, the distinction is between proactive policing and reactive policing. And this surfaces some of the factors that Brandon was just discussing in what are the police responding to and at what level, right? So proactive policing is generally the concept of officers, for example, in the Memphis case, out looking for crime, basically. They're in what they describe as these high crime areas and sort of making observations or making attempts to intercede crime proactively, as the term suggests. Versus reactive is often what we think of more in more serious cases or bigger investigation heavy cases, where generally speaking, the crime or alleged incident has occurred and the police are then reacting to it and seeking to understand what happened, who was involved, and conducting an investigation in what we'd more traditionally think of in terms of investigation, rather than these sort of stops that we've been describing that are sort of unfolding in real time, and the crime is being defined as the officers are making observations and reactions that tend to escalate in these ways.
Absolutely, thank you. And Angie Weiss-Gamble, relative to these incidents in Raleigh and Memphis and all of them, ultimately it comes down to excessive use of force. Is there a universally accepted standard there, or what kind of guidelines have municipalities widely adopted to standardize that?
Yeah, unfortunately, there is no clear standard. Typically, excessive force is any force that goes beyond what the department's use of force policy allows, but every department has their own policy and their own interpretation. So even among the question of, let's say a department has a policy that clearly lays out when they can use deadly force. Well, what counts as deadly force? Often it's defined in terms that are pretty vague. So is it something that's likely to result in serious bodily injury or death? The taser example is one that it's very easy to make an argument that it should count as deadly force because it does result in death in some percentage of incidents, but most departments do not classify it as such. So there's no clear standard, unfortunately, but there are some principles that are starting to gain traction. As Brandon was mentioning, proportionality is a principle that is used in most sort of model policies and has been adopted by a number of departments. A number of departments have also adopted bans on certain categories of force, right? So you can't use chokeholds or bans on shooting at vehicles, which has a high incidence of hurting innocent bystanders and not actually resulting in any effective policing activity. Also, putting a ban on using deadly force on individuals who only present a risk of harm to themselves is another ban that has gained some traction. But there's no clear standard. I think there are. So the American Law Institute has put out a set of principles. The Police Executive Research Forum has a set of guiding principles on the use of force that are really strong and lay out some concrete elements that are useful. And then the George Floyd Justice and Policing Act has another sort of set of principles, and it proposed that use of force only be allowed when necessary to prevent death or serious bodily injury, which I think is a really great standard to sort of analyze a lot of these cases through. And if you analyze that frame through the incident in Raleigh through that frame, I think it becomes very clear that use of force was not justified, particularly as he's running across the parking lot. I don't think you can say that he presented any harm running away. So.
Absolutely. Thank you. Brandon Garrett, I'd like to come back to something you touched on, mentioning about, people with health conditions. We saw in the case of Darrell Williams in Raleigh, after he tased, he had told police that he had a heart condition. You've had George Floyd saying, "I can't breathe." There are these countless cases where people are in custody are indicating to officers that they are having a health issue while they are being detained. Is that something that you looked at in recommendations? Are there or should there be standards for how arresting officers respond when they're told about a health problem that somebody is having as a result of their detainment?
Yeah, I mean, it's a pervasive problem that police encounter people with physical health needs, behavioral health needs, and it's not just officers, but like we saw in Memphis, even responding medical professionals sometimes defer to police, stay back, or don't act in these crisis situations in a way that could save someone's life. These problems are also pervasive after people are arrested at jails. And so, in my work as a court-appointed monitor in Harris County, Texas, it's a frequent occurrence, and we've been studying data on the number of people with mental health needs who are detained in low-level misdemeanor cases in Houston, and that's a pervasive law enforcement challenge that detaining people does not improve their health, and there are many people with special needs being held for bail, and so it's one of the dispiriting things about what just happened in Memphis is that our colleagues in psychiatry were just reminding us at the Wilson Center that Memphis was long touted as a model in terms of training its officers through CIT training on how to better interact with people with behavioral health needs, and yet they also went ahead and created this specialized Scorpions unit, an elite unit, which actually didn't have the basic tools to the same degree, or they just didn't care or focus on that training, which Memphis, is known for being a model. And that's been just a problem that many police officers are inexperienced, or some are trained, but the training may be uneven. And we can't really expect police officers to be frontline medical providers or professionals, which has been the reason why we have had this call to improve non-police responses to people who can at least be identified as being in medical crisis. But sometimes police will respond to scenes, and they need training and procedure, and there needs to be discipline and accountability when they do things that endanger people's lives. That's really only been a recent focus in American policing, unfortunately. And it's one of the we have major problems with access to adequate medical care in this country, and for that reason, we have major problems with police encountering people who are in urgent need of treatment or who have real behavioral medical health needs, and police don't know what to do, and they don't have the tools to do things even if they recognize a problem.
Absolutely. Thank you. There are a couple of threads I want to pick up on there with our other panelists. And Elada Fogel, I'll come to you first. Brandon Garrett mentioned the Scorpion unit in Memphis, and this was one of these special crime units that was developed to target high crime neighborhoods. But how is high crime defined? Are there specific data that are used, or is it officers' perception that one neighborhood is more dangerous than another? And how pervasive is that in helping cause the kind of problems that we're seeing right now?
Yeah, so to take your last question first, I think that the notion of what we're asking officers to respond to, the staggering breadth of that, as Brandon was just touching on, the attendant health concerns that often surface and are responded to in criminal interventions by policing rather than non-police interventions, I think are all interrelated, right? We've had this era of mass incarceration and mass misdemeanor and mass enforcement that goes with it, related to the question of, are we policing reactively or proactively? And I think this Scorpion unit and the notion of high crime areas brings that again to the surface. So to circle back to your first question, No, high crime areas are not well defined, right? So there are some legal principles around what is meant to be shown in order for something to be properly considered a high crime area in the context of a judge deciding if evidence can be suppressed or allowed into a case. But that's sort of the second step, right? When we're talking about policing, we first think about how did we get into court in the first place? In the context of Memphis or a unit that is designed to police in what is called a high crime area, sometimes there's data. Often it is what you alluded to of officers or the police department's general perception of where is crime most commonly occurring in any different place. You know, those tend to be neighborhoods suffering from poverty. They tend to be neighborhoods where folks of color live. And it's problematic in that it's a self-perpetuating designation, right? So if an officer or a unit or a police department focuses almost exclusively in what they deem to be a high crime area, they're going to continue making arrests there. That's going to continue to be perceived as the place where crime occurs because that's where the attention and the policing happens. And then further testing isn't really available because all of the attention remains in the same place. The second step beyond policing is where we test that in court. And that's where there is some more parameters to it. We ask for some definition. Again, this is like a common feature of things that defense attorneys like myself will challenge when a case is brought. But even in that context, you know, the Supreme Court has required that it be more than just officers' training and experience. So that's part of the calculus. There's some disagreement around the country about what needs to be shown, right? Is it necessary that it's a very specifically defined geographic area? Can be one of the questions that's somewhat unsettled. Is it necessary that the person's activity is tied to something specific, right? Can you just say generally, well, this is a bad neighborhood? Or do we say in the last month, there's been an uptick in drug activity here. So for this limited period of time, for this specific problem of drug activity, this is currently a high crime area? Or is it just by reputation, by problematic proxies for race and class, we view this as a bad neighborhood, so we're going to accept the conclusion with not much more that this is a high crime area? Those tend to be the factors that we argue about in court, but in the first instance, when police are devoting resources and attention, generally more so the former category.
Absolutely. Thank you very much for that comprehensive overview. Angie Weiss-Gammon, I'd like to come back to you on another thread that Brandon Garrett mentioned, which is people with disabilities, people with mental health problems that police are often sent to deal with when they have little or no training, and that Memphis was actually, you know, a model for how to handle some of those kind of calls. What alternatives are there to sending armed officers, you know, into a place perhaps where the subject of the disturbance, you know, maybe is disabled or has a mental health difficulty? And do those approaches, are there signs that they actually do work?
Yeah, so cities across the country have started to launch alternative response programs, and alternative response meaning no police presence. And then some are also doing co-responder response, which means typically a clinician and an EMT co-responding alongside police. And some places have alternative response and co-response programs that are working in tandem depending on the type of call. And these are being used for things like mental illness, episodes of mental illness, self-harm or suicide risk, substance use, homelessness, noise complaints, some types of neighbor disputes. And there's some discussion about their appropriateness for traffic stops as well, for traffic enforcement. Eugene, Oregon was probably the first place in the country to launch one of these programs with its Cahoots. And it, because it's been around the longest, has also been the most studied and has proven very effective. It saves the city approximately $8.5 million a year. It's maintained neighborhood safety, and it's improved health and life outcomes for the people that they're interacting with. Other programs across the country include Denver Star. There's a crisis call diversion program in Houston. Chicago has launched its CARE, which is both co-responder and alternative response. And here in Durham, we have the HEART program. And a lot of these are still in pilot phase and are still being evaluated, but early signs indicate that there's no increased risk to public safety and that really the civilian response is working quite well in these programs, which is really encouraging and exciting.
Absolutely, thank you. Brandon Garrett, I'd like to come back to you. You mentioned earlier about the need to track officers, the need to track instances of police brutality and misconduct. How can we harness data to identify these things, and what kind of standards are needed to collect it? Because it seems, as you've said, that there's a patchwork in place right now that isn't comprehensive.
Yeah. So it's important to collect information first on not just substantiated but unsubstantiated incidents involving officers. It's sometimes hard to go forward with complaints against officers. People may be afraid to follow up on a complaint, or internal discipline may not follow through like it should, but it tells you something, even if it doesn't tell you the same thing as something that was substantiated when complaints are made about officers. And these types of tracking should not be limited just to tracking uses of force by officers. Some of the officers involved in the Memphis killing had prior reports regarding not use of force, but failure to report use of force. So we care about officers' truthfulness deeply in many situations, including when there is misconduct, when there's use of force, but also when officers are taking statements from witnesses or providing evidence to support an arrest or a conviction of a person. It's important that this data be collected in a way that an officer can be followed if they move to a different department. Ideally, we would want national data so you could follow officers across state lines. Those types of proposals have not gone forward federally. And in general, we have a problem of local and state governments not sharing good crime-related data with the federal government, even on basic things like arrests and convictions and criminal incidents. So we just in general have a criminal justice data problem in this country. New York and California have passed fairly comprehensive laws requiring that various types of substantiated, unsubstantiated incidents be aggregated. It's important that to some degree the public have access, and certainly that defense lawyers have access, because it's really relevant if an officer is testifying on the stand and if there have been complaints about the officer's truthfulness, about whether they've used force against people and any number of other things, that's something that's relevant. That's what a jury wants to know about this officer. Should we really believe this person when they said, oh, this person actually, engaged in furtive conduct, or I saw this person running away from a crime scene, or whatever it was, maybe something far more serious. Do you believe this officer? Well, you need to know how this officer has behaved on the job in the past. But if that information isn't in one place, we've seen time and time again, it come up years later that, like post-conviction lawyers find out 10 years later that this officer had a whole series of complaints that a jury would not have trusted this person had they known. And we've seen convictions get reversed. We've seen wrongful convictions, and to even at great scale, in some cases, we've even seen when it's been law enforcement working at crime labs, we've had tens of thousands of convictions reversed, when only years later we find out that there were real disciplinary problems that affected the quality of their work across tens of thousands of cases. So sometimes it's dozens, sometimes it's one case, but it's one person's life sentence. It matters a lot. Sometimes it's thousands of cases or tens of thousands. The costs of not collecting good information about officer misconduct or truthfulness are enormous, and it hurts colleagues. And that said, there also needs to be due process built in, so that if an officer is on a Brady list or a list of officers where there's questions about their truthfulness, if they've been acquitted of and absolved of that conduct, there should be a way that they can review that information and contest it. We don't want officers to not have any rights in their employment. And so, in general, there needs to be a sound system for collecting and aggregating this information, but also making sure that it's correct.
Absolutely. Thank you for that very sobering explanation. Ilana Fogel, I'd like to come back to you. We had touched in your last remarks about neighborhoods and how they're perceived versus what the data says about high crime neighborhoods. There's some research suggesting that having a more diverse police force results in fewer stops and arrests. But of course, one of the things that was so shocking so many people about the killing in Memphis was that all of the officers involved were black. Is there strong evidence that a more diverse police force results in fewer stops and arrests and fewer killing of unarmed black citizens? Or is that something that you saw in your work as a defense attorney?
Yeah, I think that, the answer to this question relates back to the overall cultural context question. The data suggests that diversity can be helpful. I wouldn't contest that, but I think what's clear from the Memphis example is that alone, of course, is insufficient, right? Like some greater percentage of officers who are black still results in officers who are part of the larger culture of policing, and that clash or identity can play out in different ways, which I think we're seeing in the Memphis context, where solely by virtue of the officer's race, there's not a different outcome in the methodology of policing or the reaction to the circumstances. So clearly, I think by example that brings us to this conversation today, of course, not a sufficient intervention or reform. It's a much larger cultural question that's at play, and in all of these efforts, right, when we talk about what can be done to reform police to increase everyone's safety, it's a multi-factored response that's necessary. So without dismissing that intervention, I think it's clear that it's insufficient.
Absolutely, thank you. Brandon Garrett, I'd like to come back to you on a related issue to the issue we're talking about, with regards to allegations of misconduct. There's a lot of discussion of qualified immunity, and there's a sticking point in the passing of the George Floyd Justice in Policing Act. Can you talk very briefly about what qualified immunity is and how it plays into civil liability for violations of citizens' rights by police and this wider issue?
So the most basic thing is qualified immunity should not be a sticking point. And in fact, properly understood, police officers should actually want to get rid of qualified immunity too. And so I think there are some misunderstandings in Congress, whether willful or not, that got in the way of that act being passed. So what qualified immunity says is that in federal court, where the most sort of important civil rights actions can be brought, if your rights are violated by any government official, whether it's a police officer or the housing authority or city tax assessor, whoever it is, could be a city or state official, they violate your constitutional rights, whether it's free speech, whether it's a police officer using excessive force, whatever it is, you have the right to bring that constitutional case in federal court and get compensated for your injuries, maybe even enjoin government officials. So this is not just a policing topic, it's any kind of government misconduct. People bring a constitutional case under Section 1983, and it's a really important protection for all of our constitutional rights. It's not even just a policing protection. Qualified immunity is a doctrine. It doesn't exist anywhere in the statute. The statute was passed after the Civil War, when a lot of these civil rights acts were passed, just to say, if you were harmed by government officials, local or state, you have a right to get a remedy in federal court if your constitutional rights are violated. It's a pretty simple statute. We should be able to vindicate our constitutional rights. What the Supreme Court started to say in the 1970s was, well, we have concerns about suing individual police officers, which, during the Jim Crow era wasn't really being done. The federal courts sort of didn't even sort of pretended like the statute didn't exist. But now that we acknowledge the statute exists, of course, you can sue officers that injure you and harm your constitutional rights. We're worried that, well, what happens if an officer didn't realize that the law had changed? They didn't know about this constitutional right. It wasn't in place at the time. They were not noticed. They didn't realize that the federal courts had said something about the Constitution. And so at the time, they did something legal. During a time period, when constitutional law was changing a lot in the 1960s, before the Miranda decision, officers weren't required to give the Miranda warnings, although they probably should have beforehand. But the idea was constitutional law is changing. It's not fair to let an officer get sued if they didn't know what the law was. That part seems sort of reasonable, although we don't exactly have fast-paced constitutional change these days. But the other part was, well, and by the way, officers might make sort of reasonable mistakes, and so they violated your rights. But maybe they did it in a gray zone, and we just want to give them the benefit of the doubt. Well, the statute doesn't say that, and many Supreme Court justices who are otherwise textualists, you read the words of the statute and you follow them, they sort of said, well, yeah, we'll just bring that in because, there were common law immunities. We could just assume Congress, maybe they meant to have like a gray zone, a reasonable officer, a reasonable government official standard. But basically what that means is that a court is not allowed to let a case go to a jury over your constitutional rights being violated, even if they were violated, because the court can say, well, this officer might have been acting reasonably under the circumstances. And not only that, but existing law. Was there a case like this that the officer could have read if they spent all their time reading cases like a law professor would maybe? I don't even read that many cases. But the officer, could they have read a case just like this where someone was running across the parking lot and then got tased? Because the only case we could find around that time period, like they were running inside the grocery store and got tased. That's totally different. Parking lots versus grocery stores. Cases come down to that even. And the Supreme Court has even issued very aggressive opinions saying, well, the facts are a little different. This officer couldn't have known. It was reasonable, whatever. A lot of these decisions are quite horrifying. And it's really taking constitutional cases away from the jury, saying, well, the judge has to dismiss this case because the facts are slightly different than any case we've seen before. We haven't seen the grocery store aisle one. We haven't seen the parking lot one. And none of this is permitted by the statute. Congress can clarify the statute. But not only that, in reality, the fairness to the particular officer, the officers are not paying these damage awards. The damage awards are in fact being paid by the municipality, the county, the city. And so it's not like, Congress could also clarify that. Unless there are punitive damages being awarded, unless it's basically sort of criminal conduct by a police officer, really willful and unusual, the officer is not the one paying. And no person would agree to work for the government if anytime you got sued in your job, you would have to pay yourself and be bankrupted. So it's standard in any employment contract that if you're on the job, then your employer, whether it's the county or the city, will be paying for the cost of litigation and will be paying any damages awards. So it's all kind of fictitious that we need to protect these officers from litigation and give them this reasonableness benefit of the doubt and look to see if there's any case they could have read, which is exactly like this case. Instead, we should place the accountability where it should be, which is at the city or the county. And even if the officer did something terribly wrong, it may be because the county or the city had bad policies, bad training. We really shouldn't be blaming the officer, and we're not actually, because the officer isn't the one paying. And so the goal of these reform efforts is to just acknowledge, to get rid of the fiction that you're actually suing an individual officer. The officer may have violated your constitutional rights, but the person needs to be compensated for their injuries, and it's the city or the county that's doing that anyway. So let's just make that clear in the law. It really should have been clear already in the law, but the Supreme Court has created this new doctrine. A number of states have gotten rid of qualified immunity already, just in recent years, because there is this question, like, is this doctrine even unlawful? The Supreme Court isn't supposed to add words to statutes. Problem is that the civil rights cases in state court often don't really have the same kind of remedies available. And this is actually one of these areas. While policing is local, civil rights actions are not. They are far more robust when they're brought in federal court. So this is one of these areas where it's the federal reform, which is particularly important. And we need Congress to act, and Congress has not.
Absolutely. Thank you very much for that comprehensive review. Angie Weiss-Gammon, I'd like to come back to something that Brandon Garrett just touched on, which is the policies at the state municipal levels. When it comes down to racial bias in policing, what kind of things have worked? What have you seen at state municipal levels in terms of how cities are trying to address this, and what's working and what isn't?
Yeah, I'm not sure much is working, unfortunately. I can speak a little bit to what departments have tried. One category of things that departments have tried falls under training, right? So departments have rolled out racial equity training. They've rolled out cognitive bias training. The problem with training is that it's really hard to train an entire police force. And so often you do the training just for new recruits, or you do it periodically. And if you're only training a small number of officers at any given time, it's really hard to have a department-wide impact on an approach or a cultural view or any sort of real tangible impact. And then I think there's some efforts that I would just label as sort of approaches to policing. So I think there's one sort of movement toward community policing, which is largely done to try to improve police community relationships. And that does work well. I will say, like, community policing, when done right, can be really effective. The problem is that I think there's also this effort to do data-informed policing, which often means deploying to hotspots, which Alana touched on a bit earlier. In my experience, deploying to hotspots looks like looking at density maps and looking at where crime has occurred in the past 90 days, seeing where the hotspots look physically on that map, and then deploying additional officers to those areas, sometimes overlaying that with geographic information systems. So seeing like, okay, there's a liquor store here in this corridor where there's this activity, so we're going to deploy lots of officers to that corridor. Well, the problem is when you deploy that hotspot policing unit to the same neighborhood that you're trying to do community policing in, it undermines the community policing effort. And most departments have not gotten rid of that hotspot policing endeavors, or a lot of them even brought them back in 2020 because of the increase in violent crime. If departments instead focused solely on community policing, I do think that might have some positive impact on improving community police relationships and starting to build trust in communities of color that have been disproportionately impacted by policing historically, and where a lot of the sort of disparate impact and racial bias has hit hardest.
Absolutely. Thank you. We are almost at time. I wanted to get in another couple of quick questions. And Ilana Fogel, I'll come back to you. What we did see, obviously, in the aftermath of the death of George Floyd and some others, is police officers actually being held legally accountable, which is something that historically was very, very rare. Does this give you any hope that things, at least in terms of how police brutality is addressed in the courts, is moving in the right direction and there is a cultural shift there? Or are we nowhere near ready to say that? Is that more of kind of an isolated moment of justice in the tide of police killings that we've seen?
Well, I always like to feel hopeful. I think it's a difficult question in light of the statistical reality that you pointed to in your previous question. There are some responses. I think there are many more that are necessary. I think your emphasis or question about judicial responses is a good one, because as I've mentioned it in a few of my answers, from my focus in the courtroom, it's not just the killings and the holding of accountable in criminal charges that relate to those, but thinking back to how do we get to that point of extreme, and what sort of culture leads to these lower level interactions that can explode so violently. I think absolutely the courts have a role in that. I'm hopeful, I suppose, that it can be impactful, but it takes a tremendous amount of effort, resources for defense counsel to be able to bring those things to light in the context of cases that are not reactive to the killings, but in just the run-of-the-mill cases that I think define the problematic culture that we've been talking about, and a judicial willingness to hold those lines when the problems are brought out in litigation, right? Are the cases being dismissed? Are sanctions being issued? Is that getting back to the prosecutors and informing their charging decisions? Is that getting back to departments and informing their disciplinary decisions? So absolutely a role. It's hard to feel hopeful, when you date the question back to George Floyd, and we know what's happened in the years since then. So while hope is perhaps necessary, it can feel very difficult when confronted with repeat instances of these just really devastating occurrences.
Absolutely. Thank you. And very briefly, Brandon Garrett, I'm wondering if you can talk about this from a policing perspective. You mentioned up top your work, with the American Law Institute's Project on Policing. You work with leaders in policing. It's so difficult when we see a case like the killing of Tyre Nichols not to feel like nothing is changing. But do you feel like a cultural shift is beginning, that there is greater awareness within police forces that something needs to change? Or is that work still left to really be done?
There's enormous amount of work to do. And again, we have seen police reform efforts really flag over the past year. It's understandable that people would just become tired. It's a little sad that it depends on whether, sometimes by accident, there are cameras around capturing police misconduct, that people become outraged. It's interesting though that the city of Memphis, they were the ones with the surveillance cameras, and they timed the release of this video to sort of suit their announcements that there was going to be discipline of these officers, which was good, but all too often, even those videos, whether it's body cam videos or surveillance videos, are in control of law enforcement, and they decide when we learn about abuses. There have been situations, as we all know, where terrible footage was kept concealed from the public for months, for years. And so, there's so much that we don't know about, and even still, there are so many terrible abuses that many of us are understandably worn down. Even people like me that sit from relatively privileged positions, where I'm not worried about being in mortal danger day in and day out. We obviously really need to focus on low-level interactions as well, where police are not using deadly force, and they're not investigating high-profile shootings or killings, but the kinds of minor street-level interactions where there's some disrespect and police just escalate for no reason, like we saw in Memphis. I mean, it's another reason why, my wonderful colleague Lana Fogel has our law students working on misdemeanor cases. Misdemeanors deeply matter because they can turn deadly, but also because people who do not get tased or do not die pay terrible fines. They get arrested, they miss time from work, and they too become tired and frustrated and feel like there's nothing to be gained by trusting in our courts or in local government. It's something that can be deeply corrosive to our neighborhoods and communities and to society. So there's a reason why people are talking about structural reform of policing, and there's a reason why people are tired. And all we can do is hope that all of us who do have the energy work hard, because change continues to be very slow. And obviously people have been talking about these problems for decades now, and change continues to be slow. So.
Absolutely. Thank you. I think we will call it there. We were never going to solve this in an hour, but hopefully it will be solved within decades. Thank you, everyone, for joining us. Thank you to our panelists, Brandon Garrett, Ilana Fogel, Angie Weiss-Gammel, for sharing your expertise and opinions. We will be back on Friday the 17th to address the impact of abortion restrictions on prenatal care. If you'd like to be notified about that or any of our upcoming briefings, please email dukenews@duke.edu, or if you're watching on YouTube, just like and